All right. Welcome, everyone. Thank you so much for joining us for today's webinar entitled Punishment Without Trial, a Conversation with Professor Carissa Byrne Hessick. And since we've borrowed part of our event title from your book, Professor Hessick, let me begin by welcoming you and thanking you so much for joining us.
Thank you. I'm happy to speak with you today.
Well, we're going to have a great conversation, but first, let me tell our attendees who you are. Professor Hessick is author of Punishment Without Trial, Why Plea Bargaining is a Bad Deal, which I have in my hot little hand here. She serves as the Anne Shea Ransdell and William Garland Buck Ransdell Jr. Distinguished Professor of Law at UNC School of Law, and as the director of the Prosecutors and Politics Project, which she founded in 2018. Her teaching and research interests include criminal law, the structure of the criminal justice system, and criminal sentencing. She attended Yale Law School, where she was an editor of the Yale Law Journal and winner of the Potter Stewart Prize for the Morris Tyler Moot Court of Appeals. After graduating from law school, she clerked for Judge Barbara S. Jones of the Southern District of New York and for Judge A. Raymond Randolph on the DC Circuit. She also worked as a litigation associate at Wachtell, Lipton, Rosen, and Katz in New York City. Before joining the faculty at Carolina Law, she taught on the faculties at Arizona State University's Sandra Day O'Connor College of Law. I'm from Arizona, so shout out to you. And the University of Utah's S.J. Quinney College of Law. She also spent 2 years as Klemenko Fellow at Harvard Law School. So I feel like we are going to have a whole lot of education from that background today. Before we get started, let me just cover 3 details up front. One, yes, this webinar is being recorded. I heard the recording warning go off, so I'm very excited about that. Our last webinar, I got it posted within about a week, so you will be able to view this on YouTube in about a week, or if you're on Facebook, I think just a few minutes after the webinar ends, you can watch the recording there. If you registered for the Zoom webinar, you'll get a follow-up email in about a week with the link. And at any time, you can visit fija.org/next, scroll down to the Learn section, and there you will find a link to on-demand webinar recordings. So those are the ways you can watch this again later if you want, or share it with someone if they weren't able to attend, or if you know someone who would be interested. Second, questions. How do we ask them? If you're on Zoom, hover your cursor over the bottom of your screen and click on the Q&A icon and enter your question there. If you put it in the chat, I am less likely to see it, so please herd everything down to the Q&A icon and post them there. If you are on Facebook, feel free to ask your question through the comments. And I have my phone off to the side and hopefully we'll be glancing down at that occasionally to try and get those questions as well. And finally, if you are on Zoom, I am pleased that this year we are able to offer automatic live transcription for those who may have more difficulty hearing. To turn that button, but hit CC and that will turn captions on or off. They're not entirely accurate because it's automatic, but I have been told by several people that they are pretty good and are helpful. And I also see the internet connection unstable sign on mine. So I will also warn you, I'm on Montana rural internet, so I do the best I can. It comes out fine in the recording later for some reason. So apologies for that. It is what it is. All right, so having covered all of the preliminaries, let's begin, Professor Hessick, by sort of getting everyone set at the same baseline. And if you could do that by giving us a short definition / explanation of plea bargaining, think that would start us all kind of on the same page.
Sure. So thanks a lot. I'm excited to be here. And in order to explain what plea bargaining is, I probably just need to take a tiny step back to just remind people that when someone is accused of a crime and they get charged, they have an opportunity to tell the court whether what their plea is. Are they pleading guilty or not guilty? If they plead not guilty, then the way the system is supposed to work is that the case would advance to a trial. But we have this ability for people to plead guilty instead, to admit that they did in fact commit a crime. Now, this practice didn't happen nearly as often as it does now, but at some point, and we don't know exactly when, judges started giving shorter sentences to those people who would plead guilty. And I think part of it is, it makes sense that if somebody has said, oh yes, I did this thing wrong and I feel sorry about it and I take responsibility for it, that we might feel that they need less punishment than people who don't show any remorse for what they have done. But after a while, this changed from a sort of recognition that there is a difference in the people who show remorse to what people call the trial penalty, which is almost like it's penalizing people for going to trial. And judges did this on their own, right? They would say things like, if you're going to go to trial, then I'm going to hit you with the maximum sentence. There are examples of this from open court. Now, all of this is still not plea bargaining. What makes plea bargaining different is that instead of the defendant just pleading guilty and hoping for some sort of mercy from the judge, instead, the prosecutor and the defendant, or pretty often the defense attorney, they'll negotiate beforehand about what the defendant can get in return for pleading guilty. And sometimes they'll get the prosecutor to drop some charges. So let's say you've been charged with being a felon in possession of a firearm and armed robbery. They might agree to drop one of those charges in return for a guilty plea on the other. Or the parties might agree, the two lawyers might agree, that the defendant should serve a particular sentence. And then that would be part of the agreement. And then that's what the sentence that the judge would impose. Or sometimes the prosecutor is not willing to offer very much. The prosecutor is only willing to say that he or she won't argue for a harsh sentence at plea bargaining, or I'm sorry, at the sentencing. So it's the plea bargaining is the negotiation process between the defendant and the prosecutor to come to some sort of arrangement in return for the defendant pleading guilty. Oh, I can't hear you for some reason.
Sorry.
Now I can.
That is a great way to segue into like 3 questions I have. So I got to make a quick decision here. One is, I was surprised to learn in your book that this process was actually considered basically corruption early on. And now it's like so ingrained that judges are basically like, we can't get rid of it now. And I wonder if you could talk a little bit about how it shifted from being seen as something that was like, corrupt. To me, it sounds like people thought it was illegal, like you couldn't do that. And there were some early cases litigating over whether or not you could. So can you give us a little bit of that evolutionary arc?
Definitely. So I think part of this relates to the fact that until the middle of the 20th century or so, everybody thought that the system was working the way it was designed to. So someone would be accused of a crime, there would be an investigation, and if law enforcement thought that the person had committed the crime, they would charge them, they would bring them to trial, the jury would decide guilt or innocence, and then there would be the sentencing process for those who were convicted. So I think everyone thought that's the way the system is supposed to work. And so the crimes were written in a way that people thought that they would be applied as they were written. And the penalties for those crimes were set at a level that people thought they would actually be enforced. And so if we come together as a community and we say, you know, if you speed, if you go more than 10 miles above the speed limit, then you should have to pay a fine of $100. And we think that's the right amount. And then later we find out that people are only having to pay $50 because they've agreed to plead guilty to speeding. Then we think, what's wrong? We set the punishment at the level that we thought was correct. So why is it that these people aren't getting the punishment that we say that they deserve? So only when sort of in the early 20th century, where there were some investigations, there were some studies basically of courts in big cities, because people were trying to figure out what was going on in the courts. They could tell something was off, and there were some scandals. And so people decided to have these investigations. And those investigations uncovered widespread plea bargaining. And there was this big outcry about it. But in some ways, I think once the cat was out of the bag, not just that this was happening every once in a while, but that it was actually widespread across a number of cities. And it didn't stop, right? There was no mechanism to stop it. It became more accepted. And then we started adjusting our laws in return. We've rewritten our laws, knowing that there will be discounts for people who plead guilty. And that affects what we even say is illegal in the first place. So just to give a quick example, you know, we have this federal crime of money laundering. So you're not allowed to sort of like take money that you've gotten illegally and then cycle it through businesses that are legitimate. That's a crime. But we think it's difficult to detect money laundering. It's difficult to catch people who are doing it. So then we created a new crime of structuring transactions, where you have to report, you know, transactions of more than $10,000, not, by the way, because we think there's anything wrong with a transaction of more than $10,000, but because we think some people who are money laundering, it's going to be difficult to show that they got their money illegally. So we'll create this new crime and we'll punish people for that on the theory that they're actually money launderers, even though we don't have to prove money laundering. We just have to show that they failed to report this transaction.
That is so weird, because from my point of view, especially hearing about, oh, we're going to maybe make it $600 instead of 10,000. It's like, how does that, I'm not clear how that helps, because you just have so many people now. I mean, who doesn't ever in their life have a $600 transaction? So like, how do you find the crime in all that noise data? That's
but this is the dirty little secret of the criminal justice system, right? We write our laws and then we think the police and the prosecutors, they're going to be able to figure out who the bad people are, and we'll just use the laws against the bad people who are doing the bad things that we have a hard time proving, but they're smart enough to figure it out. And just because it would be difficult to convince a jury that the person was guilty, it doesn't mean we shouldn't punish them. We'll just give them this power to do it by proving things that we don't really think are that bad to begin with.
I'll share the dirty little secret of me reading your book, because I'm having these feelings again. It's hard to get through a whole chapter without becoming entirely enraged. But it's worth it. I hope everyone knows that one of the things that I am always looking for is like, what's the bright side? And we're going to get to some of that at the end, I hope. But before we do that, can you help clarify for us, like, under the Constitution, as far as I know, plea bargaining is not in the United States Constitution. I haven't looked at any of the state constitutions, but is it constitutional? Does the Supreme Court say it's constitutional? What is the thought process in academia or industry? Like, I take it like the Supreme Court can say it is, but that doesn't mean everyone agrees. Can you kind of give us the lay of the landscape there?
Sure. I appreciate you separating out the question of whether something's actually constitutional from what the Supreme Court says. And I should say, I'm not one of these people who hates the Supreme Court or thinks it's a broken institution. I think it's, 9 people who are generally trying their best. But here, I think that I think they failed pretty spectacularly. So the right to a jury trial is guaranteed by the United States Constitution. It's guaranteed by all the state constitutions. I'm sure that you know this, right? As someone who runs an organization about juries, you know that having a jury decide guilt or innocence is an incredibly, incredibly important constitutional right. And as a general matter, we don't let the government punish you for exercising your constitutional rights. So for example, if I got convicted of a crime and then the judge said to me, you know, who did you vote for in the last election? And I say the person that I voted for, and it's different than who the judge voted for. The judge can't say, well, I'm going to put you in jail for longer based on who you voted for. The judge can't say, I'm going to put you in jail for longer because, you know, you are a member of this political organization, or because you've written, you know, letters to the editor complaining about corruption in the courts. They can't do these things because they're constitutionally protected activity. But for some reason, the Supreme Court has decided not to extend that regular constitutional rule to jury trials. Now, part of the reason that they haven't done it is they've said, well, this is a negotiation, it's a give and a take. But even when confronted with a case where a guy wasn't willing to plead guilty and the prosecutor came back and said, well, then I'm going to indict you, I'm going to bring charges under this repeat offender law that'll cause you to spend your whole life in prison. And then he did it. And then the guy went to jail for life. And he went to the Supreme Court and he's like, look, he's punishing me for this. And the Supreme Court said, well, we have a hard time distinguishing between punishing you for going to trial and giving you the benefit of pleading guilty, because the prosecutor was allowed to bring those charges at any point. You know, the prosecutor had the power. And so the Supreme Court basically said, if we outlaw those sorts of threats in plea bargaining, then plea bargaining itself will fall apart because you couldn't give defendants anything for the benefit of pleading guilty. So basically what they said is, we're going to have to not apply our regular rules of constitutional law, because otherwise everyone will stop pleading guilty, or enough people will stop pleading guilty, and we don't have enough judges or enough courtrooms or enough prosecutors to try all of those cases. So basically they've admitted that they're not applying the Constitution when it comes to plea bargaining, but they think they have a good reason for it.
So I'm glad you mentioned that part about not having enough capacity for all of this. One of the things I noticed while reading through your discussion of that in this book is, it seems like a lot of the plea bargaining, I don't think it originated then, but it seems like it at least took an uptick during federal prohibition. Is that my imagination?
No, that was definitely, I mean, in the federal system, right? The federal system, there was a sharp increase in the number of cases being brought, and a sharp increase in the number of guilty pleas and plea bargains, because they wanted to be able to bring all these people through and convict them.
And I read in, I think it's Calvin and Zeisel. I should know the name of the book because it's like the book on trial by jury, that they basically did a big study funded like extremely well. And it was like the largest study of the jury system ever. And one of the things that they talk about in there is how jury nullification was kind of a thing in those types of cases. And so I started researching some of these, and there are hilarious stories where like jurors are drinking the evidence and then saying, we don't have any evidence, and voting not guilty. So I was kind of wondering, like, how much of this, oh, we don't have enough capacity, is because we've criminalized a bunch of things that jurors, by and large, might not even want to enforce. And so, we can't, if we put those in front of juries, we're literally wasting everyone's time and money. But if we take a plea bargain, we can get as many convictions as we want.
So I definitely think you're right that we've used the extra capacity that plea bargaining gives us to go after crimes that aren't particularly serious. So there's a woman, a female law professor, who did a big she was trying to gather information just about how many misdemeanor cases get filed, right? So misdemeanors aren't the serious crimes, felonies are the serious crimes. And she found that while we have approximately 1 million felony cases a year in like the states and the federal system combined, and all of the states put together. We have 13 million misdemeanor cases. So it's true, we have too many cases to bring all of them to trial, but the vast majority of the cases in the system are not for the sorts of things that Americans think about when we say crime. When you talk to Americans about crime, they think about serious crimes, you know, violent crimes, property crimes that are like thefts or something like that. They're not thinking about, you know, public urination or other sorts of crimes. Now, that's not to say that that misdemeanors aren't worth having. They are. I mean, you know, like in some places, simple assault is a misdemeanor, and that should be illegal too. But at the same time, I think the fact that this is how we've used our capacity is something to be concerned about. As for what juries would do if they were asked to decide all of these cases, I'm a little torn, because one thing, as you know, that the courts have also said is that we don't get to tell jurors what the sentence will be for the crimes. So if they don't have that information, that might affect their decision about whether to nullify. But layered on top of that is, you know, when I try to figure out how it is that we ended up with a system where we have 13 million misdemeanors and only 1 million felonies, I think part of the story is that a lot of Americans just use the criminal justice system to deal with things that they don't like, things that they think are a nuisance. And so I was listening to some researcher who'd done this big research project going to all of the community policing events in some city. And he said he sat there and he recorded what everyone talked about. And these are areas with, you know, some serious crime, but the comments that the police were getting were things like, why aren't you doing more things about the homeless people on the streets? Why aren't you doing more things about the low-level drug dealing on the corner? They were getting complaints about quality of life, and not things like, I see that you've only managed to solve 30% of the burglaries that occurred last year. Why don't we spend more money on that? So that's a long way of saying, although I believe in juries and I believe in democracy, I do think that we've set up a system right now where most Americans, they push for some really sort of bad policies that include using criminal punishments to deal with things that we could deal with through something other than the criminal justice system.
Yeah, that's very true. And it seems like even with the criminal justice system, its way of dealing with things is either take away your freedom or take away your money. Like those are the two big ones. And a lot of times I think about situations where I'm like, okay, I don't want this person to go to jail, but I really do want them to like maybe rethink what they're doing. And if it were me, I would like to just be like, you have to write a 500-word essay on this, you know, or have them like go do some community service to see what the effects of what they've done. And those things aren't really the main ways the criminal justice system has, criminal legal system has of dealing with that. It's basically just like hurt you this way or hurt you that way. And then later on, your odds of doing things again have probably increased if you've gone to prison because, well, you have all your opportunities for improving your life taken away. And you've just learned a bunch of new skills outside of the mainstream. And, you know, what are you going to do? You got to survive. So that's very, the whole thing is very frustrating. I'm enraged again. Okay. One of the things that you mentioned, oops. Oh, I think that's outside. I heard a noise. One of the things that you mentioned that I kind of want to circle back to is you talked about how like trial by jury is treated different, like it's getting treated differently than other rights. And I noticed a lot of this during the pandemic because like when people were told, okay, you can't go to church, immediately lawsuits, and that got overturned. And can you imagine the government saying, oh, and it's the same thing with firearms. I think California had some sort of like, okay, no more selling firearms for 60 days. And there was a lawsuit and that got stopped. But we've been almost 2 years into this pandemic with most places over a year of that time. And in some places more than 16 months of that time, there's been no trials by jury. And which I get that there's a pandemic going on. I see what you're saying. But also we haven't provided relief. Instead, we're keeping people locked up more or less at the same levels as before in unsanitary, unhygienic conditions. I wonder if you could talk a little bit about how that affects plea bargains, and B, like why is it that we treat this right so differently under these circumstances?
That's an excellent question, and I think it gets at it gets at something that's bigger than just plea bargaining. So so you probably noticed the book's title is Punishment Without Trial, and then it goes on to talk about plea bargaining. But I think plea bargaining is just one piece of a bigger shift than that we've seen in this country. It's a shift that I think happened sometime during the past 100 years. It certainly wasn't there when the country first began, or in the first century of after the Constitution was written. And that's the idea that we actually, despite the saying innocent until proven guilty, or the big sort of like legal conventional sort of the big saying that we have, that it's better to let 10 guilty men go free than to have an innocent person sort of sit in jail. I'm messing up that very famous quote by William Blackstone. My apologies. But I think we've almost turned that on its head. We've basically said, if you think that this person is guilty, we should punish them even though we can't prove it beyond a reasonable doubt. And it's okay if we end up hurting some innocent people along the way, as long as we are preventing crime. And you see that in a few different ways. One is what you just mentioned, right? The idea that we keep people in jail before trials, and we don't seem very concerned about what those conditions are like, or the fact that those conditions can lead to people not just getting COVID, but getting murdered, getting, sexually assaulted, losing their jobs, losing their kids to foster care. I mean, keeping somebody in jail before we've convicted them is pretty routine now in most of this country, even though it's not supposed to happen until they've been found guilty, except in some very few circumstances. And yet, there's a professor that I interviewed for the book, Professor Boffman at the University of Utah, and she's shown that pretrial detention, so this practice of keeping people in jail before trial, it's gotten so much worse in the past 20 or 30 years. So again, we've sort of turned all of this on its head, and I think that makes sense if you only think of conviction as just sort of like a formality, a rubber stamp in the system, rather than the only thing that gives the state legitimacy and power. And I can't help but wonder whether part of it isn't taking the jury out of the equation, right? If we as a country, and then the insiders within the criminal justice system think that only a conviction by someone's peers can give legitimacy, then basically, basically almost everything that happens right now in the criminal justice system is illegitimate. And so I think it's this mindset. I think it's pretrial detention. It's civil asset forfeiture that we see, where police officers just take people's property without even ever bringing criminal charges. It's the idea. I was doing a public radio interview last week with a prosecutor from Ohio, and he was saying, they have to give out lower charges to get people to plead guilty, because they might get acquitted at trial, and it's better to get half a loaf than nothing at all. And I was just dumbstruck by this. His point was, a jury might acquit them, so we have to get them to plead guilty to something. How can you be part of this system and say the person might be acquitted, so we'd better punish them? It's just, it's upside down land.
It is so frustrating to me to see the attitude, not only like among people you might expect, like prosecutors and judges, but like people who are our constituents who are like, well, most people are guilty anyway, which may be factually true. I don't know. But then say, so therefore, we can do these things to people who are innocent because, oh, well, I mean, they're tough luck. And it's, I have to like not use swear words. That is infuriating to me because the way I look at, I'm always thinking, what if that person's me? Do I say, well, it was my tough luck. I guess I'm going to jail for the rest or prison for the rest of my life. I mean, I don't quite understand that attitude and how it seems like one of the things you talk about in your book is how a lot of this, it's not like there was some plot to do this. It's that the culture shifted. And I think part of that is on us for kind of having that attitude of, well, individual rights don't matter as much as my tax dollars. I want an efficient system. I don't want to have any risk whatsoever when I walk out my door, or even inside my doors. And to me, I feel like, yeah, sometimes people who have done things that we really don't want being done will go free. But that's kind of you kind of got to look at that deal. And we used to think 10 of those people could go free for the value of one. And maybe not that exact math. I think he was making more of a figurative point, but that an individual's rights not being violated by the government was more important than making sure we get every last bad guy, which we're literally never going to do.
It's true. And I'll add two things. First of all, I think it's remarkable, I mean, like, look, I live on the East Coast now, and I like went to schools in like New York and New England and stuff like that, but that's not where I grew up. Like, my dad was in the military. Like, I grew up on military bases. My family's from, Colorado, and not new, like hipster Colorado, like old school, like NRA Colorado. And I talk to them about what I do for my job, and they say things like, well, the police know what they're doing and the prosecutors know what they're doing. And I say things like, it's interesting to hear you say that because you don't otherwise tend to trust the government about things, right? You don't trust the government to take your taxes and spend them wisely. You don't trust the government to make zoning decisions. You don't trust the government to make decisions about, some of them now, which vaccines are safe or not. And yet you trust them to say who should be in jail or not. Implicitly, you trust them. It seems inconsistent to me. And then I'll layer on top of that the idea that I think we forget when we talk about when there's someone is guilty or innocent, we forget that it's not always a black or white question, right? It's not just like a factual question. Were you the person in the bank with the gun saying, give me the money? A lot of these prosecutions are asking jurors not just to decide what they think happened, but to make moral judgments about them. So I'll tell you this story about a student that I had once. So I teach the first year criminal law class, and we learn things like what's murder, what do you need to do to have a self-defense claim, all of those sorts of things. And one thing that we talk about is how a lot of pieces of the law ask jurors to make moral judgments because they are asked to decide things like, did the defendant act reasonably? Was it reasonable for the defendant to be afraid? Were the defendant's actions unreasonable in this situation? So they use words like reasonable and unreasonable, and that means the jury is supposed to decide. So one year when I was teaching this class, one of my students got called for jury duty, and she actually got seated on the jury, and she had to miss some class. And the case was about a guy who was at a public school. This is a public pool. This is back when I was in Phoenix. So it was a public pool in Phoenix. And he got into an argument with a guy who ended up being an off-duty police officer. And the defendant in this case and the off-duty police officer were arguing, and the defendant ended up telling the police officer to go like F himself. He's using the F word. He's screaming at the police officer at the public pool. So he gets charged with disorderly conduct, and he gets charged with assaulting a police officer. And apparently, the prosecutor wouldn't drop the assaulting the police officer charge, even though it's a really serious charge. And so the guy went to trial. And my student goes back to deliberate with the jury, and they all agree this isn't assaulting a police officer. That's ridiculous. It's an overcharge. But most of the jurors are like, okay, so we'll just convict on the disorderly conduct charge. And my student says, but was his conduct unreasonable? And they're like, what do you mean? Like he screamed the F word in public. And she's like, yeah, I know. But like the judge told us it's like unreasonably loud and profane conduct and whatever. She said, that means we're supposed to use our moral judgment. And the other jurors are like, that can't be right. And she's like, well, we can send out a note to the judge. I just learned this in criminal law class. And the other jurors are like, no, that's fine. I mean, whatever. I scream the F word in public all the time. And they acquitted the guy. But I think it's just such a good illustration that I think even when folks get on a jury, they think they're just supposed to decide what happened, and they're never supposed to use their own judgment, even though sometimes the laws themselves are asking jurors to do that. Yeah. So anyways, it's probably too long of a story to show whether that guy was guilty or innocent of disorderly conduct depends on what the jurors think is appropriate or entirely inappropriate behavior. And while I'd prefer not to have people like screaming the F word at public pools, they do like a lot. So I don't think we should punish them for it.
Yeah. And I mean, it's now to the point where the F word, I mean, when I was a kid, it was a lot more serious than it is now. It's basically can be used as any part of speech at this point. Maybe not an article. but it's quite more normalized than it was back in my day. And yeah, that's one of the things that I kind of find amazing. It's like, if there's nothing else they can get you on, there are sort of these like, if you just think about what the name of a charge, which a lot of people seem to do, they're like, oh, he did that. Like, you know, if you're disorderly conduct, well, basically anyone can think something's disorderly. Even when I'm trying to be mild, your people say that I've like gone over, and I'm like, really? I mean, it's a judgment call. So yeah, that's just, wow, that's crazy. Okay. I want to make sure I get 2 specific questions in before we go to Q&A. If anyone has any questions, if not, I'll take those. I'll take advantage of that for more of my list. But one of them is in Arizona last summer, there was a lawsuit filed by the ACLU of Arizona against the Maricopa County Attorney's Office. Because they found out they basically have a retaliation policy, coercing thousands of guilty pleas per year. They basically say, here's the plea deal, and like the cover sheet or something like that says, if you don't accept this immediately, we're pulling it and we're prosecuting you with everything we can possibly think of. And so one of the things that I think you talked about a little bit earlier was how very different, or how basically the courts have said, hey, we don't know how to draw a line between this is like someone taking responsibility and that is like bullying and coercing. So for something like this, it seems like a pretty extreme example. I wonder if you could kind of give us some of the more extreme examples you've seen of how people get coerced, and then talk about maybe back up from there to what you think is kind of a reasonable way to do it, if there is one. Maybe there isn't.
Sure. So I think part of what's going on in Phoenix, and I think part of the reason, I don't know this for sure, but I suspect part of the reason the ACLU is going after them is because everything is in writing and it's their policy. And they're very open about it. This isn't like, oh, in this individual case, we've made this particular decision. Layered on top of that is the fact, and I talked to some folks in Maricopa County for the book, and we talk about the fact that plea bargaining has been institutionalized there. They basically have these like diversion courts that are set up. They were set up to try to allow, if a prosecutor was going to, instead of filing serious charges against somebody, allow them, for example, to do some community service instead of filing, charges against them. They basically had a court system set up to facilitate that. And what the county attorney's office has done is they use that court system now for basically everyone except people like charged with like murder or rape. And And they tell them, you have to take the plea now, otherwise we'll come after you with everything we have. And in doing that, they do it before they bring the formal charges against the defendant. And that matters in Arizona because Arizona, as I'm sure you remember, it's a pretty libertarian state. And they, at various points, have had a healthy amount of skepticism about government power and the criminal justice system. And one of the things that they did was they adopted a law saying that the prosecutor, when the prosecutor brings charges, has to turn over all of the evidence that they have to the defendant. They, most places they get to wait until trial and they only have to turn over some stuff, but Arizona was like, look, turn this stuff over. We want the defendants to see what you have. We want the process to start right away, which, by the way, makes it more like a civil case. But anyways, fine. They're circumventing this law. They're basically saying, not only do you have to take our plea bargain and give up your right to a jury, but you need to take a plea bargain and give up your right to all of this discovery information, which by the way, might show that you're innocent or might give you a sense that you could beat these charges at trial. You can't see that before you have to make the decision about a plea bargain. And I'll say, I don't know how the courts are going to rule on that ACLU lawsuit. There's a case from the early 2000s where the federal government was doing something similar with some immigration cases in terms of like fast tracking and saying you can't get this evidence and stuff like that. And the Supreme Court's like, look, it's a negotiation. If they want to make you put other things on the table as part of the negotiation, that's up to them. I think that's really troubling. And you asked for a bad example. One of the examples that I have, I didn't see it myself, but a journalist in Pennsylvania saw a prosecutor in a misdemeanor court. So a court where, a lot of the defendants weren't sitting in jail beforehand. They're there by themselves. And when they show up in court for the first time, they're given the opportunity to say whether they plead guilty or not guilty. And that's also when they're given the opportunity to say, I need a lawyer and I can't afford one. And so this journalist was in a courthouse there for some high profile case, and he saw a prosecutor approach a woman and say to the woman, here's your plea deal. When you get up to the front, if you tell the judge you're willing to plead guilty, then like, this is what we'll do. You should take a look at it. And that's what we should do. And the woman in response to the prosecutor said, oh, well, I was going to ask the judge to give me a lawyer because I can't afford one. And the prosecutor responded by taking the file out of the woman's hand and saying, well, never mind then. And the woman was like, wait a minute, does that mean if I ask for my lawyer, does that mean I can't have this plea deal? And the prosecutor was basically like, well, you can't have this plea deal. Maybe you can have some other plea deal. Like, we'll wait and see. But this one's going away. And that's awful.
Gosh.
Yeah. And no,
wow.
Is that unconstitutional?
Oh my gosh.
I don't know what the Supreme Court would say, but it's unethical. That's actually like against the ethic rules in Pennsylvania. And the fact that the prosecutor didn't care and was doing this in public, I think just goes to show how prosecutors feel about the plea bargaining process and how they feel as though they can demand basically anything as part of the process.
Yeah. One of the things that I do around this time of year is start searching all the state legislatures for jury related laws. And it seems to me, this is a casual observation, nothing scientific, although next year I'll probably be a little more methodical about it. It seems to me like there are a lot of asset forfeiture reform things. There are a lot of things about bail reform, but I don't recall seeing more than maybe 2 proposals for plea bargain reform. But the encouraging thing I definitely want to hit is you have a whole chapter in here titled Possibilities for Change, which is nice because in doing a few book groups, we've noticed those who participated in the book groups have commented that, boy, you get to the end of one of these books about these things and you're just depressed. So I want to let everyone know that there is some hope at the end of this book. So if you decide to join us for a book group on this, that's an incentive. But B, can you give us a little bit of idea of how we might go about fixing this? Do we have to fix laws? Is it a litigation question? And maybe, as you just kind of alluded to, maybe there's something in ethics rules, or what are some things that could potentially be productive in fixing this?
Yeah, so unfortunately, I think the ethics rules, aside from that one really bad example I gave, don't hold much promise here. And yes, changing laws would go a long way towards this. Removing mandatory minimum laws would go a long way towards this. Getting rid of a bunch of low-level crimes that we don't really think people should be punished for would also go a long way towards fixing this. But I don't think, I don't, I think it sounds daunting to talk about those things, right? Because I think that the average American's like, well, I can't get my state legislature to pass a law. So what can I do? And I do think that I think average Americans can do a few different things. First of all, if you could ask for jury duty, go to jury duty. Maybe we could all stop complaining a little bit more about, as much as we do, about jury duty. So then it doesn't seem like this big cost on the community to have people go to trial. I think we can also be much more skeptical and informed voters when it comes to prosecutor elections. So 45 states here in America elect their local prosecutors. Most of us don't know who our local prosecutor is. We don't know anything that they've done. We don't know any of their policies, and we have no idea how they use their power for plea bargaining. It's worth asking those questions, sending a letter to your local prosecutor to try to get information. When it comes time for an election, ask these questions. Go to any candidate forums that they're having and ask questions about plea bargaining and how they use their powers and how they make sure that they're not pressuring people into pleading guilty. That's one thing they can do. I think the other thing that we can do is we can start talking about how we think this is an abuse of power. If we change the culture, I think that can also change how people act. I'd say judges actually have a lot of power here. Unfortunately, they've largely been the bad guys in this story. Well, they certainly haven't been the heroes, and at times they've been the bad guys. But I think that, asking for judges who take the Constitution more seriously, I don't think that that means that they're judges of a particular party. I think, some of the judges who've taken stances against plea bargains were constitutional conservatives, and some of them were, rehabilitation-based liberals. I think it's really a question of how seriously they take the Constitution more than what we might call politics. And I think the last thing that we should do is we should all say that, our states need to do more to fund public defense. And really that we should just try to educate all of the people that we know about plea bargaining and how it warps the system. That's why I tried to write the book. I do think that, you're right. I've seen a groundswell against things like civil asset forfeiture. And I can't help but think that's because of the awareness raising that we've seen. The Washington Post, the New Yorker, they wrote these big exposés about abuses. There are good organizations out there doing ground level work. The Institute for Justice comes to mind in DC. So I think the more people are aware of it, the more it might actually, spark calls for change.
Anyone who knows me for more than maybe a year probably is familiar with how incredibly stingy I am with saying one nice thing about anyone in government. So buckle your seatbelts. That moment for the year is here. I will point out, as Professor Hessick has accurately pointed out, that judges have not been very helpful in this regard. There is one Judge Jed Rakoff, who actually has written quite a bit about this problem. And he has a book that I just Googled him to make sure I had his name right. And I just saw that he has a book on why do the innocent plead guilty. And that kind of, so I give credit where credit is due, and that's about as far as I can go. I don't know that much about him, so I don't want to be too kind, but that encourages me a lot that someone in that sort of position is actually recognizing, acknowledging, and talking about this problem and that it needs to be reformed. One of the things that I definitely want to hear from you is, and I skipped this earlier because I wanted to make sure I had time for other questions related to plea bargaining. But can you discuss a bit about what we lose when we have plea bargaining dominating the system and not jury trials? And especially, like, I'll just make a little note that one thing that I've been extra sensitized to this by the COVID pandemic, because as a convenient side effect of all the horrible things happening in the jury trial system, we actually have gotten to see a lot more jury trials online, just because they have to require the public fulfill the public trial requirement. And they're not doing that by allowing people in the courthouses for the most part. They don't want to pack a room full of people who could potentially be passing illness. So to make it public, it's been online. So we were able to see Derek Chauvin's trial. We were able to see Kyle Rittenhouse. I believe that the trial in Georgia, I don't recall the defendants' names, for the killing of Ahmaud Arbery was either online or televised. The only ones that have uniformly not been televised or accessible to the public in any meaningful way, in my opinion, are federal trials, which to participate or to listen into, you have to register. They send you a phone number and you have to sit there on the phone. You're not even allowed to record it to listen to later. So that says a little something about them. But can you talk a little bit about what we lose when we have plea bargaining instead of trials by jury, especially now that people can actually see them in a reasonable way?
Sure. I mean, we lose a lot of things, right? We lose some of the things that I've talked about before, like the match between the punishment fitting the crime, that goes out the window. I think we take things like pretrial detention for granted and we allow it. But there are other things that we lose too. I mean, one thing that we lose is we lose the sense that we've figured out what actually happened, right? When people plead guilty, they're often pleading guilty to a different crime than the one they were charged at. And what we lose is the ability to know what they actually did. Did they commit that serious crime that they were charged with, but not the one they were convicted of? Did they actually commit no crime at all, but they were pressured into pleading guilty to this other charge? So we lose, I'd call it the truth-seeking feature of the justice system. Layered on top of that, I think we lose the ability for victims to feel a sense of closure, right? Because this all gets worked out behind the scenes, and then they're told things like, well, yes, we know that, your loved one died, but he's going to plead guilty to something else that's not about killing someone. And I think that upsets them. I think it dilutes the moral message of the criminal justice system, because there's a sense that the plea bargaining is about shading the truth, if not eliminating the truth altogether. And then we also lose public participation in the system. We as a community don't have a sense of what's happening in the courthouse. We don't have a sense of, whether the people who stand up and speak in our name are doing things that we agree with or that we don't agree with. And then we also, I think, lose the ability to participate and to be heard. I mean, I'm sure you probably know this, right? But the people who wrote the Constitution thought that we needed jury trials because they thought jurors were supposed to participate in the handing out of justice. And that's largely fallen away, and we aren't involved in it at all. We don't feel any sense of ownership over it. And it's frankly hard for us to figure out what's even happening.
Yeah, and one of the things that I am really try to emphasize to people is there is no jury nullification without trial by jury. Certainly a small portion of cases would be affected by that, but it can be an important message when you get repeat, nullifications on a particular law or a particular topic or a particular way of enforcing it or something like that. And just not having that, I think really, especially when people are focused on efficiency, hey, I don't want to spend money on these trials. Well, okay, you don't get that feedback and get these laws dealt with, then you're going to just spend the money instead on imprisoning people. So it's not clear to me that there's an easy financial way of sorting that out and which way is more efficient. I want to I've got 3 questions now. let's hit these three questions just really briefly, and then I'll give you the last couple of minutes to fill in any blanks you think we may have left. Grant Todd asks, what do you think is the most effective coalition of efforts in changing our approach to justice? I'm not totally sure what that means, but I'll let you take a stab at it.
Yeah, so I mean, look, I think it's important to get lots of groups involved here. I think that when we have people working across the aisle politically, we're more likely to see change. I also, I direct something here at UNC called the Prosecutors in Politics Project. And we just did a big study of lobbying in the states. And we found that when prosecutors support criminal justice reform, it's more likely to pass. So I do think it's about, trying to get folks from different walks of life, and then also trying to get folks within the system to help champion reform as well.
And we might be able to sort of combine these two. I'll read them both, and then you can kind of combine as you see fit or not. Barry asks, I may have missed this, but how do states' experience of plea bargaining differ between states that elect prosecutors and those that don't? And the second part of that, which maybe is combinable with the next question, is, have you done any international comparisons on the problem? Ed asks that he seems to recall reading that Europe has addressed the need for a more efficient approach than jury trials, and asked if you're able to add any detail there. So maybe that can be combined with Barry's second question.
Sure. So look, the states that don't elect their prosecutors, they have a more centralized system. And because they have a more centralized system, that means that they can basically set policy across the state. And sometimes that policy touches on plea bargaining. Back in the 1990s, Alaska tried to ban plea bargaining for a lot of cases. I'll note it still didn't work. There was still this sort of under the table plea bargaining that happened, but that's not the sort of thing that you could ever coordinate across districts the same way in states where they elect their prosecutors, because the individual prosecutors have a lot of power and they use that power differently. Like, it's quite clear from the data we have, but even from interviews with prosecutors, that they hand out different types of bargains depending on where they are. As for what they do in Europe, here I'm quickly getting out of my depth. I'm not an international or a comparative law scholar. Obviously, they don't elect their or maybe not obviously. The United States is the only country that elects its prosecutors. They're really not about sort of having politics and democratic accountability in the criminal justice system. They actually think it's wrong. They think it's wrong to politicize it at all. And their prosecutors don't have as much power. They're more functionaries. A number of them have actually like an inquisitorial system rather than an adversarial system. So the system itself is supposed to be getting at the truth of what happened rather than having two sides present information and then letting a jury figure it out. I mean, does that mean their system is more efficient? I mean, I think it's probably efficient on some level because all of the people who are working to figure out what happened, as opposed to what are the best arguments that we can make. But they also have systems with much smaller footprints. They don't put the same number of people in prison. Their criminal laws aren't nearly as expansive. They also don't have the same crime rates that we do. So it's hard to draw comparisons. And then I'll say the last thing, the sort of the keeping politics out of the system. That also means their system doesn't reflect what people in those countries want. I mean, people always talk about how the United States has the death penalty and Europe doesn't. That's because it's not because people in Europe don't support the death penalty. They do. Like there were some studies a couple decades ago, and the majority of people in like Germany wanted there to be capital punishment, but they don't get to control their system. The criminal justice elites figure out what to do, and they're just like, yeah, no death penalty. So it's a different system. Again, I have my problems with democracy and accountability and the political system, but I think I prefer it to the alternatives. Even if I don't like the outcomes sometimes, I think it's the better process.
Well, thank you so much, Professor Carissa Byrne Hessick. For those of you on Facebook or Zoom Live, please scroll through the comments or the chat. You'll find there a link to Professor Hessick's page on the UNC School of Law website, as well as a link to fija.org/next, where you can sign up for Fija email, learn about a book group we will be organizing regarding this book, and how to join us for other events and other information that might be of interest to you. And if you are watching this recording on YouTube, I will have those links in the description. Thank you so much. I should have scheduled 2 hours because I certainly could go another hour if I had thought to do that. But I do want to give you the last word here, as I do all of our guests. If there's anything that you want to emphasize, anything that you feel like we skipped, anything that you feel like maybe needs clarification, the floor is yours.
No, I really appreciate the chance to come and to speak with you and the folks who are affiliated with your organization. I obviously think juries are very important. One of the reasons I wrote the book is because juries have been disempowered. And the last thing that I'll say is, obviously people, when they serve on juries, should make whatever decision they think is right. But to the extent it matters to you, we used to have juries acquitting a lot more people than we do now. It's hard to know why exactly that is, but I do wonder whether people are taking the standard of proof beyond a reasonable doubt seriously. That's a very, very high standard. The question should not be, does it seem plausible that the person did it? Was the prosecutor more convincing than the defense attorney? It should be, is there any reasonable reason to think that the defendant didn't do it? And if so, then you should acquit.
I am glad you said that. We should definitely do a webinar on that standard, because I won't even get started because there's too much. That definitely needs its own hour. So I will look into that. Thank you so much for everyone participating live on Zoom or Facebook. Just quick share with you a comment from Barry. Barry says, thanks for such a great session. Really interesting and informative. I haven't browsed all the Facebook comments because I got about 4 different things going on the screen here. But thank you so much for your time and wisdom. I hope all of you will visit fija.org/next and sign up for our Fija email, because that is the first place I will be sharing details of our book group as soon as we get that scheduled. Punishment Without Trial: Why Plea Bargaining is a Bad Deal by Professor Carissa Byrne Hessick. Thank you so much.
Thank you. It was my pleasure.
Take care, everyone.